Imagine there has been a tragedy in your community. At 9 a.m., the neighbor's 4-year-old son went out to play in the backyard. By 11 a.m., he was no longer alive. At 11:30 a.m., your neighbor went out in the backyard to check on something in the garden, and shortly after, the neighborhood is filled with her screams as she comes upon the kind of sight that no one should ever have to encounter: her own son, deceased. And standing above him, unashamed, is the killer, the perpetrator. Worse yet, this isn't some stranger. The killer's been living with this family for years. What do you do in such a situation? What does the community do with such a heinous criminal? Arrest, definitely. And then life imprisonment, maybe capital punishment, depending where you are. This is the kind of crime that has to be prosecuted to the fullest extent of the law. But what do you do if the killer is an animal? If the killer is a pig? A literal pig? Today, I'm talking about medieval animal trials. Beginning as early as the 13th century in France, domestic animals would be put on trial for murder and sentenced to capital punishment. The predominant species tried in such situations was the domestic pig, with over half of legal actions taken against animals being directed towards pigs in pre-modern France, but could also include horses, cows, and dogs to a much lesser extent. These criminal trials often involved the appointment of a public defender to represent the accused, sometimes a short stay in an actual jail for the defendant while they were awaiting trial, witnesses being summoned to testify on both sides, and almost always a professional executioner, professional hangman being brought in, usually from out of town, to finish the job. All of this happened at the state's expense, and the verdict in criminal trials was almost always guilty. Which is interesting for a lot of reasons. One of which being that in an agrarian society where pork was being raised for meat, probably like half of the town had the skill set required to just take out a pig. So why all of the theatrics? Why the procedural drama? And all of that is just on the criminal side. There were also ecclesiastical trials of animals, where a group of villagers would essentially bring a civil suit against a group of pest animals for destruction of property. In these cases as well, a defense attorney was appointed to represent the group of animals. Witnesses would be called, sometimes expert witnesses, to testify. And eventually some kind of settlement or verdict would be reached where oftentimes the animals would be asked to leave town or be excommunicated. Though to be fair, while the word excommunication is used in a lot of sources discussing this, it's really more like cursing them, anathematizing the animals, which is just an official church curse, rather than literally excommunicating them in terms of canceling their church membership. Because they're animals, and animals can't be Catholic. Now that would be ridiculous. I keep going back and forth on whether this is a funny or a serious topic. This is one of those topics that really highlights how different the medieval worldview is from the modern worldview. There are a lot of parts of medieval Europe that I think feel really familiar and recognizable to people today. These were societies where a very small number of elite, super powerful, wealthy people who were born into privilege had pretty much total control over the majority of the population, normal people who were working for a living, just trying to get by day to day. There was extreme inequality between men and women, with women being seen as sexually voracious, sinful, and generally speaking, just a little worse than men in every conceivable way. Very medieval red pill manosphere, if you will. Also, the plague and kings going off to incite violence in the Middle East. Do I even need to comment on that? The overall point being, even if things were different, even if things were more extreme, there's a lot of parts of medieval history that feel really relatable to the present moment, at least in my opinion. In the words of Charlie XCX, I think the apple's rotten right to the core, from all the things passed down, from all the apples coming before. So to me, what makes animal trials particularly interesting is how totally unfamiliar they feel. So today, I want to talk about medieval animal trials. I'm going to talk about criminal trials and ecclesiastical trials, what purposes they served in medieval French society, what logic allowed them to happen, and why at the end of the day, they might not even be that medieval. Let's start with a discussion of criminal trials. How does the criminal trial of an animal work? Most likely, the animal offender was identified to the judge, bailiff, magister by a citizen. Remember, there aren't police in this time, so somebody probably had to find an authority figure and say, hey, this animal killed my child, killed my neighbor's child. Again, most of these cases were about the death of children, unfortunately. And then, after the report, the animal may be formally charged with the crime of murder. This would lead into the court proceeding. In some, but not all cases of criminal animal trials, they would have some sort of public defender, some sort of lawyer basically, appointed to represent them. In the case of the 1457 trial of a pig in Sévigné-sur-Étang, described in detail by Sven Gibbs in his article, there were 9 named witnesses brought to testify in the proceedings, and other witnesses who were not named, but who were referenced as having come in. So at least 10 witnesses involved in the trial process in front of the judge. The owner of the pig, Jehan Bailly, was summoned to court to testify and justify the behaviors of the pig at least twice, but he didn't show up either time. It seems like maybe he didn't want the heat from the situation. Now, Jehan was named as the defendant, but he wasn't imprisoned and he wasn't facing any consequences. The consequences and the imprisonment and all of that was put on the pig. So although he's named as the defendant, he's not really the one on trial facing any consequences. It's all about the actions of the pig, not even about his liability in keeping an eye out for the pig to make sure it didn't get up to something like this. It's hard to know how many trials actually went to trial in a courtroom in that kind of manner, because the records that we're working with a lot of times are actually payment records of executions, for example. So there aren't necessarily full surviving court records of the back and forth dialogue between a prosecution and a defense. For a lot of these, it's just kind of receipts that, people have found and said receipt for costs related to trial of pig, for example. So we don't know exactly how in-depth all of these trials were. It seems like in a lot of cases, once the charges were brought against a pig, it was pretty much just, okay, execution time, but not always, such as in this case mentioned with Jehan Bailly, where all of these witnesses are being brought. For a normal murder trial in medieval France and other parts of Europe, specifically medieval Flanders, there would often be other options for conflict resolution that didn't involve execution. So there would often be an option for a certain amount of penance, for compensation for the family, reconciliation with the family of the victim out of court. So those sorts of options a lot of times would be available to human defendants being put on trial for murder, but not available to the pig. Likely because the pig can't provide compensation to the family, but also because they are not being treated exactly like a human defendant, right? They don't have the same rights in a criminal court. Sometimes during the trial process or awaiting trial, the pigs would be imprisoned. Not always. So they probably were usually confiscated and at least moved to the barn pigsty of an official, taken out of their normal environment and moved somewhere else. They weren't always held in a literal, dungeon jail cell, but sometimes they were. There is a 1349 record of a pig being kept in prison in Normandy, Pont de l'Arche, in a prison cell for 146 days awaiting trial. This was noted in L.B. McGregor's article about animal trials, and what's also notable about this is the jailer is being paid the same daily rate for keeping a pig as he would have been for a human. So there are side-by-side records of a human and a pig being kept in different jail cells awaiting trial for comparable amounts of time, and the jailer's being paid the same amount of money, not being paid less money because it's a pig, okay? And then at the end of all of this, execution. Because, to be honest, if you're bringing a pig to trial, usually there's an eyewitness who says, I saw the pig on the kid, it didn't look good. Pig, horse, cow, maybe sometimes a dog, whatever the case may be. Executioners were professionals. It wasn't just like you draw sticks and then someone from town has to be the executioner. Executioners are doing a really tough job in medieval society because obviously killing people is bad. So there's really a kind of social distinction of, okay, that's an executioner, yikes, which allows the rest of society to kind of keep their hands clean. So that means the executioner is a professional who is being brought in, again, at the government's expense, from out of town. As noted in L.B. McGregor's article, in 1393, an executioner had to travel 35 kilometers, which equates to about 22 miles, to perform an execution of an animal, the hanging of a pig. And to be clear, that's not 22 miles in a car, obviously, medieval Europe, that's 22 miles on horseback, at best. And in 1386, another executioner traveled 80 kilometers, about 50 miles, to perform the execution of a pig that had killed the grandson of a local wool trader. The farther the distance they have to travel, the more it costs, right? So this is expensive. These are expensive trials because who's paying for this? The pig's not paying for this. The owner of the pig isn't paying for this. So why is this allowed? Why is this happening? What is the logic here that is enabling the trial of an animal? Because in modern society, if an animal kills a human or does something that's deemed very dangerous, it may be ordered to be put down by the court. The owner may be fined. The owner may have to also do something. But there isn't a question of the guilt or innocence of the animal as much. The animal is not being put into a human jail cell. And the argument in modern times when somebody puts down an animal in that kind of situation is usually something to do with, this animal is dangerous to society, this animal cannot continue to be around, we don't trust the owner to take care of this animal and make sure it doesn't impact people. It's not an argument of this animal is a criminal who deserves to be put down as a result of their actions. It's not the same argument as for human people who are executed, exactly. In the Middle Ages, many people were fined or sent on pilgrimages or had to do some sort of penance in the case of many crimes. Or in some cases, they would even have an ear cut off, like, ooh, squicky, bodily mutilation, don't like that. Hanging, execution, capital punishment was really reserved for the most extreme cases. And in Review of Medieval Animal Trials in Flanders, M.J. Pardon points out, a lot of cases also involved the confiscation of the animal by the court, the sale of the animal, the fining of the owners, situations other than the animal being executed by the government in that way. Even in human cases where the human was a criminal, execution was really reserved for the most extreme cases in medieval Europe. So baseline, capital punishment and a trial of an animal in a criminal court is reserved for the most extreme cases, the most heinous crimes. And as we've talked about already, the death of a child is pretty bad. It's pretty extreme. Esther Cohen and L.B. McGregor both express the same idea concerning the execution of animals, which is that essentially in the medieval worldview, which is based largely on Christianity, Christian theology, animals are created for the purpose of serving humans. Either animals are meant to be food, animals are meant to be pets, animals are meant to provide ingredients for medicine, all those weird medieval recipes you see where it's taken a hoof of a zebra or whatever. The idea is all animals are meant to serve humans for human benefit. And so the subversion of that, where an animal is not only not to human benefit, but a domestic animal in the environment with the community, has caused harm to a human, is such an extreme subversion of that original purpose, one could say. And the death of a child is very extreme and tragic. So, in order for an animal to be put on trial for capital punishment to happen, it has to be viewed as a very extreme situation. Still, what's up with that? What purpose does it serve to put that animal on trial? As Sven Gibbs argues, the punishment may serve as a deterrent for the human keepers as well. So making a whole public spectacle where the animal is being put on trial, you're being asked to come defend your animal's actions, it doesn't look good on you, and it's kind of a cautionary tale to other local animal owners to let them know to keep their shit on lock, because otherwise things could get weird. He also argues this could be a demonstration of justice done right to all the spectators. Nobody can get away from the law. Nobody can get away from justice. Not even nobody, people who aren't a person, a pig. No one's getting away from the law. Everybody's facing justice here. A lot of the different components of an animal trial are in place seemingly to preserve the legitimacy of the trial, okay? By having the animal go through many of the same steps as a human defendant would. Putting an animal in jail or separating it from the community in one way or another, whether that's jail or, as I mentioned before, the magistrate's pigsty. This pig is being distinguished as a criminal, being removed from society. It's a symbolic separation. The use of the hangman also gives validity and lawfulness to the procedure. Nobody's cutting corners. We're following things by the book. Whereas, the farmer just killing the pig is a little bit more rogue justice. And if we're being honest, that probably did happen sometime. We just wouldn't know because there wouldn't be a record of that. In northern France and in Burgundy, there was also a practice of hanging an animal upside down by its feet. So there's a visual signifier of this is an animal, this is different, this isn't being treated like a human. So the processes of justice are still being applied, but how that looks is different. To emphasize that even though the animal still has to be accountable for its actions in a way, even though the system of justice cannot be stopped, there's still recognition that this is an animal and humans are superior. So the animals are upside down, reflecting an inversion of the natural order. And the fact that it's unnatural for an animal to kill a human and unnatural for a human to have to sentence an animal to death. So they're dying in an unnatural, unchristian way. And on the note of unchristianity, unfortunately, in those areas, the same punishment was applied to Jewish criminals, which is so unspeakably anti-Semitic that I actually don't even know how to say how bad that is. Like, it's evil, it's bad, it's awful. What other words are there? Now, I'm not going to get into the level of anti-Semitism today, but I couldn't talk about this without mentioning that some of these statutes, they'll say these apply to pigs, cows, horses, and Jewish people. So that's pretty fucking evil. Oh, yeah, But the argument here is that the way the animals are treated in execution highlights still human Christian exceptionalism. Now, MJ Pardon, in her article about this, talks about the idea of objectification. So, in some of these articles, authors talk about the dehumanization of human criminals and the humanization of animal criminals, right? Because it's weird for us to see an animal being put through a human justice system, and the way humans are treated within that justice system also dehumanizes them to a level, and they're both going through the same experience. MJ Pardon's argument is more along the lines of humans and animals are both being treated as objects once they're being seen as that level of criminal. No longer a person who committed a crime, but a criminal as a third kind of object category where they're no longer being seen as a person. So a human can be a criminal, a pig can be a criminal, and even a bag of spices can be a criminal, because bags of counterfeit goods were burned in the same way as a human criminal could be executed by burning, done by the executioner. So MJ Pardon's argument there is that this is kind of a function of a system that overall turns criminals into objects and no longer treats them as human members of society. And because of that, because the end result is objectification, it's easier to group in objects and animals into that process anyway. And here's another point I'd like to make. All justice is ritualistic in some sense, especially in a community where there is a standardized system of justice in some way. X happens, which is unforgivable, unallowable, and so Y has to happen in order to correct that unforgivable act. So some sort of action has to be performed to correct, the first action in order to restore the order of the community, in order for people to have a feeling of security. Something has to be done with a trial or community justice. Something has to happen to bring things back into the normal balance of things. At one stage, this may have looked more like a folk ritual, and then later becomes a ritual of the state. So having a trial, an animal trial, a trial of a pig, is a way for the government to demonstrate that they have the power to repair the community after some kind of incident, after a tragedy. A demonstration that the government has the capacity to impose justice, even in unlikely situations. Maybe with the hope that with the justice being imposed, that will somehow satisfy or avenge the family who was wronged. But of course, the criminal trials are only half the story. What about the ecclesiastical trials? An ecclesiastical trial is a trial held by the church. The word ecclesiastical just means churchy stuff. And an ecclesiastical trial is different from a criminal trial when we're talking about animal trials in a few ways. Because first of all, a death is usually not involved. Second of all, there is not one single defendant. It is pretty much a civil suit brought by a group of people against a group of animals. So what does that mean? What does that look like? The details of the summary I'm about to give were taken mostly from Esther Cohen's Crossroads of Justice book, but also Paul Schiff Berman's article on animal trials. All the sources are going to be in the description. Ecclesiastical trial against animals. It starts. a judge receives a complaint. An example of a complaint might be, all of these rats are eating up the wheat field in this town. That's not good. Do something about it. The judge would then have to send someone official to evaluate the complaint, evaluate the damage. They send someone to go take a look at the wheat field and see how much damage has been done to the wheat field. Is it actually as bad as people say? Then, because this is a church trial, they'll order some public processions and prayers and penance to soothe heaven's anger before the trial begins. So, appease God first, and then we can start with the trial. When the trial starts, a procurator is appointed to represent the animals. This is a Roman law term, a term from church law. I'm gonna basically be calling that a public defense attorney because that's functionally what it is in this situation. And then, for the trial to begin, the animals are sent a summons. So a summons goes out to the rats in the wheat field saying, please present yourself at court and defend your actions. Much of the time, it was assumed the rats will not be coming to court on account of they can't read the summons, they don't speak English. And then the trial would go ahead with the defense attorney without the defendant being physically present. The defense might use a few different strategies in a case like this. 1, wasting a bunch of time. 2, once the trial opens, claim the church doesn't have jurisdiction over the animals. 3, try to defend their client's actions. Here are 2 exemplary cases that I simply must share with you. These are both from the 16th century. I'm sorry, I know that means they're not medieval, but it's very close to being medieval. And I think they were probably doing the same arguments in the 15th century, and we just don't have records of it, so this is the best we have to go off of. Also, these are so good, so either way, I'm just gonna tell you about them. First, ecclesiastical trial example. The trial of Bartholomew Chassenet and the rats of the village of Autun. The rats of the village of Autun in France were accused of causing damage to the fields of crops. Bartholomew Chassenet was appointed to be their defense attorney to represent them. The court issued summons 3 times to the rats, asking them to come to court. The rats did not appear. The lawyer, Bartholomew Chassenet, argued the summons was not properly served. It was only given to a group of rats, and really all of the rats of the area should be informed since they would all be impacted by whatever the ruling was. And the court said, of course. So the priests in all of the parishes in the diocese of Autun had to announce new summons, so the rats of all the parishes in Autun are alerted. And yet still they did not come to court. Come on. So Chassenet argued that the time allotted to them was too short. They didn't have enough time to travel. Their legs are too small. They can't move that fast. They got small legs. And they were not given appropriate protection on their way to court from cats in the area who were lying in wait, preparing to ambush them. The conclusion of this trial is not recorded, but Bartholomew Chassenet went on to have a superstar legal career in France. So it was very successful. He was very well regarded for his work in this case. Second ecclesiastical trial exemplar, the Weevils of Saint-Julien. This one is taken from the Berman article. The last one was taken from the Cohen book. Now, also 16th century, in 1545, the original complaint was made by the wine growers of Saint-Julien. They were saying, the weevils are here, they are messing up our vineyards. By May of 1546, so it seems like at least 6 months passed since the complaint was filed where this was in review in the court system. In May, the case was dismissed. And the church said, do a bunch of public prayers, have some vigils, appease God, do a bunch of Catholic ritual stuff. And then there was a follow-up signed document that was attesting that, yes, we did all that stuff and the weevils went away, so we're good now. Well, you may think that's where the story ends. 30 years later, the weevils return. Return of the weevils. Counsel was appointed to defend them. At least 2 lawyers, whose names I have read, Pierre Rambeau and Antoine Filiol. So 2 defense lawyers for the weevils. Here is their argument. The weevils have a right to the vineyards because creatures and bugs were created before man. So maybe it's their vineyards anyway. François Fay, the prosecutor, said, no, creatures and nature were created to serve man. They should be serving us, not messing up our vineyards. And then the 2 defense lawyers came back at him and said, okay, well, just because weevils and other animals are subordinate to man doesn't mean that we have the right to impose our rules on them and excommunicate them or curse them or whatever. While the lawyers are busy arguing, the townspeople all come together and decide, let's put some land to the side. Let's put aside a bunch of land near the vineyard for the weevils so they can move. They don't have to leave town. They just move out of the vineyards, and here's some nice land for them to inhabit. This is, by the way, the townspeople are having a meeting in the town square discussing this. And they decide, the weevils can have this land. We still want to be able to walk through it. We want to be able to get to the spring that's on the other side. But how about this? They go live there. To be honest, I feel like that's kind of a generous offer. The defense team said, we're going to need some time to review your offer, consult with the weevils, confirm that this is okay. So 6 weeks later, the defense has been evaluating the offer, and they come back and say, this land is sterile and it is inhospitable and it is insufficient for our clients. Our clients need better land. This is not good enough. At which time the court adjourned. Court said, time out, and got hired an expert witness to go check out the land to determine whether or not the land was actually insufficient for weevils to live on. So they had someone go evaluate the land. How did this case resolve? It is unknown. Apparently, the last pages of the document summarizing the case were destroyed by mice or bugs. So, did the weevils not get the outcome they wanted? This is a side note. I feel like that's a pretty generous offer to give the land to the bugs. It's very defense attorney vibes. It's interesting. Think about a defense attorney who has been charged with seriously defending the weevils. And I feel like even a modern defense attorney, if they're taking their job seriously, they're like, no, more injustice. So I've given you 2 examples of trials with unknown endings. How would a trial like this conclude against a group of bugs or mice? Generally speaking, if the animals lost the case, which they didn't always, because a defense attorney could say they've been here first and the court might approve of that, for example. But if the animals were to lose the case, then usually they would be told, you have a week to get out of town, or else we're gonna curse you. You'll be cursed, anathematized, which is an official church curse, or exorcised, exorcism on the weevils. One example, 1487, a trial in Autun, back again. Multiple animal trials in Autun. Apparently they love this shit. They convicted successfully a group of snails who were doing damage to the farmer's property. So the bishop instructed the rectors of all the parishes to get all the parishioners together, march with holy water and crosses, chanting to beg God and the Virgin Mary and all of the saints to rid the town of this pestilence, and to keep doing a procession like that for 3 days. So, why is this allowed to happen? What's the logic here around the ecclesiastical trial? Because it's not even like the criminal trials where serious bodily injury has happened and they have to deal with that. They're not even trying to kill anybody. They're asking the snails to move out, to rehome themselves. So, to be clear, the whole church actually didn't support this. A lot of places they were like, this is fucking stupid. This is stupid and ridiculous, and you shouldn't do that. Thomas Aquinas, for example, said, I don't like that. He said specifically, no to anathematizing non-human animals because they don't have any sense of reason. And if they are there messing up the town, then it's probably because God sent them to punish the people, kind of like a swarm of locusts situation. So A, they don't have reason, and B, maybe you deserve it. Maybe God sent them. Which also, that was kind of an argument that the defense attorneys would use too, is like, well, this is probably a punishment from God, so it's not their fault. That being said, even though the church was kind of split on this, a lot of people still did it anyway, and because the church is international and not subject to any local laws, local rulers, that kind of thing, animal trials in the church, the ecclesiastical version, actually spread farther than criminal animal trials, just with different dioceses, parishes, whatever. They were going on. But here's the thing, because the animals didn't hurt someone physically, and because it's a group of animals, the objective isn't the same as with the criminal trial, right? Just like a civil suit versus a criminal suit in today's culture, society, whatever, don't have the same end result. It's trying to actually change or cure an ongoing situation rather than seek justice for a situation that has already happened. In the words of Esther Cohen, indeed, being part of an adversary procedure, ecclesiastical sentences aimed not to exterminate or punish, but to obtain relief for the plaintiffs by getting rid of the pests. The very idea of exorcism does not imply destruction, but the removal of a noxious element. Not destroying the snails, but removing whatever is causing them to do damage, removing the spirit of Satan that's causing them to do damage, or just rerouting them to less damaging behavior. And Esther Cohen also notes the end result is kind of the same. Like, it's kind of, if the animals win, if the animals lose, it's pretty much just going to be a bunch of prayer, a bunch of praying to God anyway. So in a way, it doesn't totally matter who wins or loses. It's the use of some sort of legal mechanism to incite the church to be involved in solving a problem for a community that they don't have any other solution for, right? They don't have medieval pest control. They don't have really any way to deal with a large group of pest animals other than to invoke God. And how do you get the church to help you invoke God on a larger scale with more authority? It's to start a legal trial. And of course, medieval people used prayers and the church to try to solve a lot of different problems that they didn't have other solutions to, because they didn't have science and medicine in the same way that we do now. They had to rely on God for a lot of things. And so, of course, pest control, why not? And in a way, through the court process, they can determine if they are being punished, why, find some kind of answer, explanation through the verdict as to why this is happening. Because if the defense of the snails, if the defense provides a good argument and the church accepts that, then the church is, accepting and ruling on what the situation is. So if the defense is saying these animals were here first and that's why, and the court accepts that, then the people kind of maybe have to accept that, well, it's because the snails were here first, that's why they're messing your whole shebang up. Or if the defense argues that it must be God sending the animals to punish people and the church accepts that, then the people know they have something to atone for. They're being punished for some reason, which, to be honest, is kind of a blanket statement as far as medieval Catholic culture goes. You're atoning for something at every given moment. What do you mean? But in a way, it's kind of using an official church judicial procedure to find answers for a situation that doesn't have an explanation in their minds. So, animal trials. Are they really medieval? The answer is kind of yes. Ecclesiastical animal trials are definitely kind of medieval in character, but I want to set those aside for a moment and focus on the criminal animal trials. The earliest criminal animal trial, allegedly, is the burning of a pig for killing a child in 1266 or 1268 in Fontenay, outside of Paris. Whether or not this was actually a trial has been debated by authors like Colin Frank, because the records indicate the pig was burned for killing a child, doesn't indicate that there was a whole court proceeding involved. It could have just been a community ritual cleansing, getting rid of the pig after that. It didn't necessarily happen through the court system. Now, looking at the book by E.P. Evans, this book is a little bit flawed. It's outdated. It was published in, I think, like 1906, and it doesn't have a complete record of every animal trial, but it is acknowledged by most scholars to be the most comprehensive compiled list of animal trials that we currently have. So, according to the E.P. Evans book, the next criminal animal trial was a trial of a bull in 1314 in Noailles-le-Temple. I'm sorry for having too much fun with these French names. That is a medieval time period. 14th century. 15th century, phasing out of medieval. 16th century, not really medieval anymore. And the peak of prosecution of non-human animals was between 1500 and 1700. I made a nice little graph data visualizer of the date ranges of all of the trials listed by E.P. Evans. Again, that's the best comprehensive list that we have. So you can see my data set somewhere on the screen. I don't know where I'm putting it. It should be mostly accurate. It could be one or two numbers off. It's just me counting on my fingers. You can see this is a distinctly not medieval but rather early modern data set, that things really do peak after the medieval period. Over the course of the 15th century, so the 1400s, there was a decrease in fines and pilgrimages and other types of punishment being enforced on people, and an increase in corporal punishment and executions. As summarized by M.J. Pardon in her article, rates of fines, bailiff compositions, penitential pilgrimage, and banishments fell, and an elaborate system of corporal punishments took their place. There was a shift towards spectacular, as in making a spectacle, not spectacular is good, a shift in spectacular punishments that people could watch. A fine, a pilgrimage, those are things that happen in private or take you out of town. Those aren't things that the whole community is gathered together to see. And as she also states, this is an expression of the formation of modern statehood. A punishment like paying a fine or going on a pilgrimage, which is, I don't know, almost like sending someone to a rehab facility. I don't know what to compare that to in modern terms. But those sorts of punishments were really about trying to rectify the situation, serving as a deterrent to a degree, but also helping to remedy whatever the situation is, right? If a fine is paid and the money is given to a family who had goods stolen from them, or had a child die or something like that, it's a way to try to help fix the situation, heal the community to a degree, and then the more extreme punishments are reserved for the more extreme cases of things that were really socially unacceptable, right? So something like murder, not always, but in cases where it was determined to be just so evil, not in the heat of the moment in a fight, but, a planned murder of someone, something like that, things that are truly socially unacceptable have to be punished with execution, and that could be done and would be done in a public forum so everyone could see. That's the medieval mindset. And then over the course of the 15th century, there's a shift towards less of these private resolutions and more of the public spectacle, the making an example of somebody. I'm not able to speak to whether or not seeing someone publicly humiliated in the stocks or whatever would make you feel better as a victim than receiving money from a fine, but there's a shift towards more punishing people physically, bodily, in a public setting. And the fact that it's public and that the whole community is then involved, they have to see what's going on and be aware of it, is a function of the move towards early modern statehood, because the government, the central authority, has to demonstrate its power to the people in visual means. A fine or a pilgrimage doesn't do that as effectively as public execution, public shaming, any of that stuff. So in earlier medieval times, before the feudal system really took off, maybe there would be problems that were really localized in the community, and they would have smaller community resolutions based in the law of the community. And then in the feudal setting, that expands just a little bit because things grow a little bit, and then you have the manor lord or whoever is overseeing that whole group, and things expand a little bit. There's maybe a little bit more need for control of the community if you're a lord who's trying to keep control of the community. But that's still pretty small. You're trying to keep the peace between the people that you're watching over and make sure they don't do anything that messes with you. And for much of the time in medieval France, they were going according to customary law, which is the customs of the area. This was not written down until the 13th century, I believe, when they started writing it down, not to say, okay, here's the law, it's written down, which means now it's enshrined, but rather as a way to provide guides to people who were just trying to defend themselves in court, a reference text for people representing the state of the law as they were writing it down. And of course, writing it down has a transformative property, etc., but it wasn't like, okay, I'm a lawmaker, I'm making the law, and I'm writing it down. It's like, okay, well, what are people saying on the streets? What are we saying in the court, okay? What has been going on? The customary law was basically the community agreement of what the rules were and what the punishment for those rules were. And it could vary parish to parish, diocese to diocese, town to town. People could complain about the customary law for this whole region is the same, except in this one town in the middle, they have their own customary law, and I broke the rules there and I didn't know. There are documents like that complaining about it, but it's kind of a local consensus that would be impacted by the church, the Lord to a degree, and of course the king if any new rules were really made, but there wasn't this system of legislation like we have today. And then towards the end of the Middle Ages and into early modern times, moving out of the feudal system, there's more and more emphasis on the assertion of authority by a central figure of power. So the king is the figure of authority, and an effort to sort of make laws consistent across different areas, impose rules that are consistent over the whole kingdom. So it's not just like everybody's kind of self-governing in their own wacky little regions, but rather the king has control over everybody. And that's to help undercut the power of the feudal lords, which eventually leads into centralized government, absolute monarchy, which wasn't quite as much happening in the Middle Ages as it was at the end of the Middle Ages and then early modern time period. So in a way, animal trials can be seen part of this trend towards a central authority figure imposing laws on people and the need for the visibility of the justice system. It's not just what can we do to resolve this among neighbors, but more and more how can we visually demonstrate justice to people, have people associate the idea of justice with authority and the government. Nobody is above the law, not even a pig. So of course these are kind of medieval because they started in the Middle Ages, but much like witch trials, they started in the Middle Ages as a function of the transition out of the Middle Ages and the characteristics that started appearing in the end of the Middle Ages that would eventually become the early modern time period. The threads that ended up building up into this other time period, which is when they really took off, because as I said, 1500 to 1700 is when animal trials are really popping off, okay? That's America. The American colonies are happening during that zone with the peak of animal trials. That's no longer medieval. And I have tried so hard to find some kind of through line between animal trials and witch trials, since it seems like they kind of have an overlapping peak. I have not been able to do that yet, but I have like 6 more books that I'm reading on witch trials right now, and so I'm hoping to find a way to connect these things, other than the fact that they're both manifestations of state power and choosing a quote-unquote scapegoat for assigning responsibility for some kind of tragedy to a individual within a community, or, you know, there's some common threads. I want a smoking gun. I want something more specific that ties them together. So anyway, animal trials, kind of medieval, but also not entirely. I am Saphael. At this point, animal trials have nothing to do with my art history master's degree, but that is how I learned how to effectively read a lot of books in a short amount of time. So I guess I'm using those skills in a different way. My Hildegard von Bingen video last week got such an insane reception. So y'all are crazy for that. Thank you. I'm scared. So many people are watching it. Oh, what do? I will be making more Hildegard von Bingen videos, okay? I promise I will. I've got other stuff to look at. The witch trial stuff, as mentioned. Probably going to talk about syncretism in the church, syncretism in St. Bridget of Ireland, different options, maybe some other saints, we'll see. I hope you liked this video, if anyone watched it. It's very different from the last one. That's why I'm being so about it. I know this isn't the same subject matter. This is law. This is medieval true crime with cows. Oink, oink. If you want to subscribe and like the video, that's really nice of you. Either way, thank you for watching if you got this far. That's crazy. I'm feeling very bashful right now. I'm still just like processing my last video doing well. So, you know, thank you. I tried to improve the framing of this video. I tried to improve a few things. You'll let me know if that worked. But anyway, thank you, and, you know, hopefully I'll see you next time.
Au revoir.
Au revoir.